Well, hey there, and good morning or good afternoon, depending on what part of the country you are calling in from. My name is Ginger Bell, and I would like to welcome you to our first funding webinar. We're talking about compliance considerations both before and after a data breach. And I'm excited to share this information with you. As you are getting logged on, I want to first of all thank First Funding for bringing this information to you. A very timely topic, a very important topic, and we're going to cover a lot of information today. So as you're getting logged in, you can listen two different ways. You can dial in and call in the phone number that is listed on your Zoom meeting or on your email, or you can listen through your computer. We do have everyone muted. This is a very popular webinar and we have a lot of you on. So unfortunately, we do have you muted, but you can ask questions. Two different ways you can do that. You can type it into the Q&A box, type it into the chat box. We do have a lot of information we're covering today, so we may not get to questions, probably going to hold questions to the end. And at the end of the webinar, I will actually have a question box come up and you can type in your question there. So if you do not get your question answered through the content that's being covered, then you can definitely submit a question and we'll be sending up a follow-up email that will cover the FAQs. And so we'll provide that for you. Other thing is we do have today's presentation available and I'm going to put it into the chat box. So if you would like to click on the link, I have a copy of the slide deck that Sean is going to be going through, so you can get that. We also are recording this session. I will send out a copy of the recording along with the slide deck to everyone tomorrow. So with that, I would like to turn it over to Greg Chafin, who can introduce our speaker for the day. So Greg, are you there?
Yes, I am here. Can you hear me okay?
I can hear you now.
Okay. Super. Hi, I'm Greg Chafin. I'm Director of Marketing over here at First Funding. For a bit, most of you may or may not know me. I started out as Senior Account Executive and then went to National Sales Manager, and I handle all the marketing. And I'd like to present Sean Stevens. Sean is a certified mortgage banker, but more than that, Sean has been a customer of First Funding for over 10 years. Sean has gone out and gotten his certified mortgage banker and went out and got a law degree because apparently he wasn't busy enough originating loans. He's got 22 years of the mortgage experience. Metroplex Mortgage Services is still a customer of First Funding, and Sean still originates. So he's used our warehouse platform. He's managed his own business, and he's got a unique understanding of the pressures and the regulatory concerns facing mortgage bankers today because he's done it and he's been doing it for a while. And so I would like to welcome Sean Stevens to help us out today and talk to us about compliance and cyber risk. Sean?
Greg, thank you for that introduction. And it's been a long time. You guys have been a great partner to work with, and I appreciate the relationship over, gosh, all these years. So as you can see from today's program agenda, we will be covering the key compliance considerations that you as a mortgage lender should have in place to protect both your company and consumers from a data breach, as well as the steps that need to be taken in order to ensure that you and your companies are able to respond in a compliant manner should a data breach occur. At the outset, I will lay a foundation and explain what constitutes a data breach. We will then review how federal regulations and various state laws treat the definition of a breach, along with the all-important notification requirements that are owed in connection with a security breach. Once you understand what makes up a data breach, as well as the applicable federal and state regulations that apply, we will then go over the importance of establishing strong data breach policies and procedures, which are partly based on the four-pillar approach to data protection. As we progress through the four-pillar approach, I will also provide example steps of what our clients have actually put into place in order to help illustrate ways to strengthen data breach protection policy and procedures. Next, in the event a data breach should occur, we will emphasize how time is of the essence, the fact that the steps of your response should be standardized, and most importantly, we will walk you through an example of a data breach response checklist that will help you and your companies incorporate proper response protocols and timing to your relevant policies and procedures. Remember, all it takes is just one attack for your systems to go down. And because there are so many various forms of attacks geared at obtaining personal information, we will then review the different types of data breaches and the ways in which mortgage lenders can mitigate their very real and substantial risks. The building block of any data breach response is maintaining appropriate insurance coverage. And because we routinely hear confusion from the mortgage banking community about what E&O and cyber insurance policies actually cover, we will walk through and compare E&O versus cyber insurance, as well as highlight key points taken from an example declarations page. Of course, due to the many different laws that can apply, it can be difficult for companies to fully understand their potential liability and the responsive steps that should be taken in the event of a breach. For instance, because the consumer and state attorney general notification requirements can vary from state to state, I will also provide a detailed explanation of what your notification obligations are after a breach, as well as outline some of the potential consequences for one's failure to respond. Now, on the next slide, before we begin, please understand that nothing discussed in today's program constitutes legal advice or creates an attorney-client relationship. If you have specific issues at the conclusion of today's program, please reach out to your counsel, or if you'd like to further discuss, you're welcome to contact me directly. As for a brief note about our firm, Johnston Thomas is a full suite boutique law firm, which has nationally recognized mortgage banking group. With an experienced team of mortgage banking lawyers, Johnston Thomas Mortgage Banking Group is known all across the country for the experience and results that it brings to the areas of regulatory compliance, mortgage banking litigation, and a broad range of mitigation services. In being at this point, I would say a mortgage dinosaur, just on a side note, I would say that's what really attracted me to the Johnston Thomas team, because I had really specific, with my mortgage experience, I wanted someone that talked the same as I did, understood the nuances that we go through on a day-to-day basis. So that's one thing that really attracted me to their team, is their specialization in the mortgage lending field. So as we begin, why is data breach compliance so important? With data breaches and cybersecurity attacks on the rise across our country and the world as a whole, especially with regard to those businesses that are entrusted with highly sensitive and confidential information, today's topic is especially critical for mortgage bankers, brokers, and lenders, since they are responsible for both obtaining consumers' private personal information as part of the mortgage application process and protecting such from unauthorized disclosures. Albeit, most people associate risks of a data breach with highly tech-savvy computer hackers. But the reality is that data breaches can come in a variety of contexts, and mortgage bankers must be comprehensive in their efforts to protect all that sensitive information which has been entrusted to them. For instance, in addition to the risk of a data breach that comes with ransomware and other such similar attacks, data breaches can also result from faulty computer systems, employee negligence, internal bad actors, and the list goes on. As a result of our ever-changing business environment, where most business is now done online, all businesses, including mortgage lenders, must seek out and obtain the necessary education to fully understand the entirety of the data breach threat and take active steps to mitigate the harm that can be done to your business and customers. In other words, if businesses fail to obtain the necessary education and implement comprehensive loss mitigation steps to prevent and/or reduce the harm from data breaches, the short and long-term consequences can be devastating. For example, if a mortgage lender suffers a data breach, it can cause great harm to the consumer through financial loss, identity theft, and the resources expended to recover from the breach, such as credit freezes, identity monitoring, and the overall time spent due to the breach. Additionally, the loss of business and personal reputations in the community can turn into a major long-term consequence, since consumers are expecting that mortgage lenders will secure their personal information. However, because data breaches result in an immediate loss of consumer trust, this leads to a reduced customer base, lower loan volume, and diminish the reputation you have worked so hard to build. The loss of time, energy, expenses can be substantial due to any business downtime suffered, the energy expended in following proper breach response protocols, and costs involved for items such as forensic investigations, which can be extensive. As we will discuss shortly, notification requirements vary by state statute and include your reporting obligations to consumers and states' attorney generals. Strict compliance with a state's notification requirements are essential to mitigating exposure, because a failure to do so can result in heavy penalties and be crippling to a mortgage lender's operations, which I'll show you an example of here shortly. Legal ramifications after a breach can include fines, penalties, and possible private rights of action, which all take away from the bottom line at a time where margins have already begun to compress. To underscore the importance of today's topic, in March of 2021, a mortgage company agreed in a settlement to pay a $1.5 million penalty to New York State for violations of that state's cybersecurity regulation. Residential Mortgage Services, RMS, a licensed mortgage banker, experienced a breach that exposed the sensitive personal data of mortgage loan applicants in 2019. This went unreported, and it wasn't until July 2020 that Regulators discovered evidence of the breach as part of a safety and soundness examination of the company. As part of the settlement, RMS agreed to pay a $1.5 million penalty and undertake improvements to its existing cybersecurity program. Now, as mentioned by Ginger, due to the amount of content provided in today's webinar, time constraints will not permit us to answer questions at the end. However, please submit any and all questions that you may have, because we'll be following up with a comprehensive FAQ that will be distributed to all attendees, and that will address most, if not all, of the questions that are posed during today's program. Now let's move into what constitutes a data breach. Although states have varying definitions for what makes up a data breach, a breach will generally consist of the following elements: the unauthorized or unlawful acquisition of personal information in which compromises the security, confidentiality, or integrity of the personal information. Please note that the definitions of both personal information and breach can vary from state to state. Let's now compare and contrast between California and Texas. For example, on this slide, we show the definition of personal information as provided by the California Civil Code. Within this definition, I would like you to pay particular attention to the bolded words such as name, signature, social security number, address, telephone number, and driver's license, since those are all commonly collected as part of the application process. The definition also includes employment, employment history, bank account number, credit card and debit card number, or any other financial information, which are also normally obtained through the application process. Now, as you can probably agree, this definition is quite extensive. But because most of the information included within the California definition of personal information are standard items obtained during the mortgage process, this should be a particular concern to mortgage lenders, because it is not just limited to a borrower's social security number, as some may think. In contrast, on our next slide, we show the Texas Business and Commerce Code definition for sensitive personal information, which is defined as an individual's first name or first initial and last name in combination with any one or more of the following items if the name and the items are not encrypted, as you can see by the bullets below. Once again, these are common pieces of information obtained during the mortgage application process. And while both statutes have similar elements, they also have different requirements. This comparison highlights the importance of understanding the data breach laws and definitions within the states that you conduct business, because what constitutes personal information in one state may not be the same as another. Now, along with the definition examples of personal information we just discussed, states also have varying definitions for what makes up an actual breach. Understanding what makes up a breach is critical, because once a breach occurs, this triggers additional legal obligations to the mortgage lender. In this slide, we are once again comparing and contrasting the California Civil Code and the Texas Business and Commerce Code. I bolded the similar wording found within both statutes of unauthorized acquisition of computerized data that compromises the security, confidentiality, or integrity. And although both breach definitions are similar in nature, they each also contain different requirements to be aware of. Like the comparison we reviewed under personal information, this emphasizes the importance of understanding the data breach notification laws of the states where you conduct business, because a failure to do so can result in severe penalties, as you have seen. Now that we've provided example definitions for personal information and breach, let's next review individuals who could be a potential target of a breach. As you probably can imagine, hackers want to exploit vulnerable targets that can lead to a high probability of success. In high volume and stressed mortgage environments as we are in today, this can lead to a greater chance of accidents by those involved in the mortgage origination chain. Remember, all it takes is just one busy LO, processor, or other staff member to inadvertently click on an email which contains a malicious link for an attack to occur. Potential targets can include, but are not limited to, the following: employees, such as loan officers, processors, underwriters, closers, and management; independent contractors, your systems or networks; and vendors located within the mortgage supply chain. Next, we need to examine why the mortgage industry is so ripe for a data breach, because understanding where we are today is a step towards protecting our companies and sensitive personal information in the future. A common myth we hear is that hackers only go after large companies. Many lenders, brokers, and bankers may not think they are big enough to be hacked. However, smaller companies can be at the most risk due to lack of infrastructure, training, and resources. Additionally, COVID-19 created a perfect storm, which forced upon us the remote workforce without the ability to properly plan and implement security measures. As a result, remote workforce threats can include improperly secured remote desktop protocol, also known as RDP, employees accessing unsecured personal devices for work, no multi-factor authentication policies, which is commonly known as MFA. For example, one of our lender clients requires MFA for all users to access any company resources, which include email, SharePoint, and even when they log into their LOS. The benefit of having MFA procedures in place is that it protects the company by adding an additional layer of security, which would require a malicious actor who is trying to access an account to have both the logon credentials as well as the user's phone in order to gain access. However, without MFA, only a username and password would be needed for access, which leads to a higher risk of a data breach. Failure to use secure internet sources, which includes both unsecured public wireless and also unsecured home wireless connection. Does your organization have policies in place that require minimum security standards for your remote workforce? Lack of a firewall or virtual private network for remote work, as well as an overall lack of physical safeguards in a remote environment, which could include family members using the same device or failing to keep family, friends, or guests away from your home work area along with any of that sensitive data as well. And a failure to utilize IP address restrictions when possible. This is a feature which allows access from certain IP addresses while denying access from external sources. Remote printing is another area that is often overlooked. If your users have the ability to print from their home, does your company have in place policies to prevent the printing of sensitive borrower or company information? One scenario to consider would be if a remote user prints a borrower's loan application out at their home. Then a third party steals that information by physically taking that document or even by way of a picture. At this point, a breach has now occurred and the user would have no idea that it even happened. If your company allows remote printing, policies should be in place to ensure that sensitive information may not be printed, or systems that provide for the proper disposal or destruction of such documents. These are just some of the real-life examples our lender clients are taking to help mitigate the risks associated with the remote workforce. Now, I would love to see examples from our attendees on ways your companies are being proactive in mitigating these remote workforce threats. So if you have a moment, please go ahead and submit these through the chat feature. Now let's discuss the federal and state regulations which affect data breaches. As you can imagine, the impact of data breaches can be wide-ranging. So understanding what federal and state regulations which apply is critical for planning a proper response. From a federal standpoint, under the GLBA and through the Safeguards Rule, the FTC, as well as other federal agencies and regulators, enforce data protection rules for consumer banking, finance, and lending. However, it is important to point out there is no federal data breach notification law. While only a handful of states have enacted privacy regulations as of today, many don't realize that all 50 states have varying security breach notification laws. And remember, the breach notification laws of the state where the consumer resides will apply, not where the security breach occurs. For example, if you have a security breach in California, which affects borrowers in a variety of other states, you have to be aware of the various data breach notification laws of the states where the borrowers are affected. As a result, it can be difficult for companies to clearly understand the full extent of their responsibilities. Beyond the analysis of applicability, many cannot separate their information technology infrastructures to comply with varying state requirements, as well as those at the federal level. If a mortgage lender is unable to comply and meet these requirements, then they run the risk of suffering hefty consequences. We understand this topic can be downright overwhelming, and our team at Johnson Thomas is known for helping our clients navigate the various laws, explain when they apply, and understand the associated risks. So please reach out if you have any additional questions on this topic. On the next slide, we are now comparing the regulator notification requirements between California and Texas. As discussed previously, a breach triggers additional obligations with notification laws outlining those requirements. You can see here that California requires more than 500 residents to trigger notification to the Attorney General, while notification in Texas is required if the breach involves at least 250 residents. Notification requirements, timing, and penalties can vary. So it's important to not just take a one-size-fits-all compliance approach, especially if you are licensed in multiple states. An important compliance consideration for data protection involves establishing a strong policy and procedures program. As provided by Microsoft, this four-pillar approach to data protection can help lay a foundation within your policy and procedures. Remember to not disregard the importance of policy and procedures, because in addition to other compliance considerations, many investors are also requiring for you to attest at time of recertification or application to the existence of such. Now let's quickly review the 4 pillars of assessment, governance, training, and response, along with some actual examples to tie in their applicability and importance. Under assessment, this provides the context for implementing security controls. First off, you will identify the assets and data of the organization. For a mortgage lender, these could include borrower or employee personal information. You will also need to understand any contractual requirements involving the data, such as mortgage loan purchase agreements, your cyber insurance policy, MLO or employment agreements, vendor agreements, IT, and the like. You will determine any regulatory requirements surrounding the data, such as state and federal, as we just previously discussed. Define who within the organization should have access to the data. And through risk assessment, this involves organizations reviewing the risks, value cost, and solutions surrounding the data. As an example, one of our clients has utilized the cybersecurity risk tool from the Federal Financial Institutions Council, FFIEC. This is just one risk assessment tool that can help your company to start identifying your company's cybersecurity risk profile and also to measure your cybersecurity preparedness. Now, this is just one example of how companies are assessing their cybersecurity risk. And for your convenience, I've included their link on our resources page at the end. Now let's review the role that governance plays within the 4-pillar approach. This provides a direction for cybersecurity within the organization. Governance will include policies and procedures established by top management, as well as the organizational systems and frameworks used to manage cybersecurity. Documented procedures are able to assist in standardizing tasks so that they are performed consistently and correctly. It also establishes a cybersecurity personnel responsible for managing cybersecurity within the organization. As another example, to help tie in the role that governance plays, one of our clients established actionable risk-based policies instead of relying on an end user by implementing security features which block all company resources from non-US based login attempts, unless they can pass a second level of authentication, such as MS, which we discussed earlier. This allows for there to be no end user impact, while at the same time protecting the company from a malicious entity outside the United States. Additionally, we have clients who implement email link filtering provided by Microsoft Defender. Instead of relying on an end user to hover over links in an email before clicking, or relying on an administrator to be the one who permits email delivery to the end user, this policy allows email to be delivered and the filtering analyzing of the link to occur when a user actually clicks the link and tries to access the URL. These are both great examples of a mortgage lender being proactive by establishing actionable risk-based policies instead of relying on the end user to make the correct security decision. Now, the next pillar of training is especially critical because weak points can be exploited by hackers. Employees with access to personal information are at risk of ever-evolving social engineering schemes, which are increasingly convincing. Loan officers, processors, underwriters, management, and vendors can have access to highly sensitive personal information. Training is essential because it helps maintain the skill levels needed in order to recognize and deter those attacks targeting them. It also educates employees on company cybersecurity expectations through policy and procedure training. As an example, each employee should know who to contact for reporting a suspected cybersecurity incident and relevant incident indicators. To help illustrate this point, we have multiple clients who train employees by implementing phishing training. This includes emails being sent to end users which appear to be legitimate, but are actually email that the user should be able to recognize as being malicious or harmful. These emails could be delivered from email addresses they don't recognize, emails that contain misspelled words, and even emails with similar domains they're used to seeing, but just slightly off, such as abc.com versus abc.net. Now, there may be a link or attachment, and if the user clicks on the link or attachment, they fail the test and additional training is required. There are a variety of vendors who provide phishing training, which include Microsoft. Now, if a data breach occurs, your company must be able to properly respond. As we move on to the fourth pillar of response, this is critical because it involves business continuity and disaster recovery. These plans establish procedures for data resiliency for maintaining systems. A key question to ask is, how much downtime can your mortgage company withstand? Factors to consider would be the incident response time needed for investigation, restoration of the data, providing notification to those impacted, and remediating the issues. Communication plans should be in place, which identify what will be said, who is the appropriate party to say it, and who will be notified through what medium. Now, although we will talk more about this later, be careful not to waive the attorney-client privilege by communicating privileged information to other parties. Once again, this four-pillar approach to data protection can be a resource which helps lay a foundation within your policy and procedures and better protect your organization from harm. We just briefly spoke about how important a proper response is. And on this next slide, let's now move to analyzing data breach response protocols. Many of the following steps that we will be reviewing should already be outlined in a mortgage lender's data breach protocol procedures. However, if your company does not have data breach protocol procedures currently in place, these actions should be completed as quickly as possible. If you need additional assistance in updating your policy and procedures, we can be a resource to help you incorporate these all-important steps. As we touched on previously, mortgage lenders should have security procedures, breach protocols, business continuity, and disaster recovery plans as part of their policy and procedures. These plans should also consider who will keep the business running in case a data breach should occur. As part of your data breach response protocols, you should have an incident response team designated, also referred to as an IRT. On this slide, it shows this internal team should include one employee from every key group and should cover all aspects of your business, such as network engineers, technicians, HR, legal, PR, and marketing staff. Additionally, on this next slide, as part of your data breach response, you will need to contact external support resources, such as the insurance carrier and legal counsel who will be critical to managing the incident. Identify insurance coverage and applicable insurance requirements. Legal counsel will be able to assist in identifying any legal obligations and regulatory requirements. And as mentioned earlier, remember to clamp down on unnecessary communications immediately. The attorney-client privilege is very powerful and protects those confidential communications between an attorney and their client, which relate to the rendering of legal services. However, inadvertent admissions of fault can lead to unforeseen legal ramifications. Disclosure of privileged communications can result in a waiver of the privilege. Next, we will review how critical it is to create a communications plan and schedule. A data breach procedure should also include a messaging deployment schedule and an escalation process for the key team members mentioned previously. A communication plan should follow the legal notification requirements for notifying all parties affected by the breach, such as customers, employees, vendors, regulators, and more. This process is a vital step that sets the timeline and alerts the victims about the specific data that was compromised. It is crucial to maintain a timeline because data breach laws have requirements for providing notice, which include timing, the method of notice, and who must be notified. On this next slide, the first step in the identification or detection process is to understand the attack vectors and to focus on those areas. Depending on the type of breach, it may be difficult to identify where the fault lies, which is why it is so important to timely file a claim, so your insurance coverage can be used for forensic expenses, which can add up quickly. As it progresses to the containment phase, your incident response team focuses on limiting the damage and preventing further injury. The incident response team should focus on preventing additional harm to data and engage in activities that help identify the attacking host. Short-term containment activities involve rapid response to limit the damage, while long-term containment focuses on getting systems to function normally and preventing the threat actor from moving within the system and networks. At the eradication stage, incident handlers remove all the attack components and work towards restoring your affected systems. The recovery process then brings the affected system back online after testing, monitoring, and validating that attackers will be unable to compromise the system again. Now, on this slide, we show if a breach were to occur, it is important to have established procedures on how to respond, because every moment that is wasted can result in additional data exposure and liability. And once again, if you need assistance in creating any of these data breach response protocols or procedures, please reach out because we can offer assistance in this matter. Different types of breaches. Now, up to now, we have analyzed the compliance considerations you should have in place prior to a breach, as well as proper response protocols. Now let's review examples of different types of breaches to be aware of. As a starting point, data breaches can occur by accident, such as through an employee leaving an unsecured laptop in their car with sensitive information that gets stolen. Every owner's potential worst nightmare. It can also occur through intentional conduct, such as a rogue employee or malicious actor. Data breaches can occur in multiple forms, such as ransomware, physical security breaches, various phishing schemes, malware, and password breaches, to name a few. Ransomware attacks can be extremely crippling, as evidenced by the recent high-profile Colonial Pipeline incident. The Federal Trade Commission defines ransomware as a form of malicious software that infiltrates computer systems or networks and uses tools like encryption to deny access or hold hostage until the victim pays a ransom, frequently demanding payment in Bitcoin. In these situations, cyber criminals infiltrate a system in a number of various ways. Gain access to confidential, private, or sensitive information, and then proceed to hold the systems or data hostage until the ransom is paid. If the demands are not met, the system or encrypted data remains unavailable, or the data may be deleted or even exposed. As you can imagine, mortgage companies are especially vulnerable to these security threats due to the sensitive nature of the information they use and store on a daily basis. However, if you decide to pay, beware that additional compliance considerations will apply, such as through the Office of Foreign Assets Control, also known as OFAC. If you decide to make the ransom payment and the malicious actor is listed on OFAC's sanctions list, OFAC may impose civil penalties for sanctions violations based on strict liability. This means that a person subject to U.S. jurisdiction may be held civilly liable even if it did not know or have reason to know it was engaging in a transaction with a person that is prohibited under sanction laws and regulations administered by OFAC. Also, if you decide to pay, how the payment is made could impact whether your insurance claim is denied or covered. In many situations, the insurance carrier has the authority of whether to make that decision or not. Next, we will move to the important topic of physical security breaches. These can occur when data is lost or stolen that is contained on items such as USB hard drives, laptops, tablets, smartphones, desktop computers, and other devices. As we discussed in the remote workforce threat section, this can be a topic of considerable concern to the mortgage lending community. As important as it is to understand the black letter law, it is also equally important to show how this can be applied to a mortgage lender's day-to-day activities. For example, one of our lender clients has put into place a policy where it alerts them when a certain number of files are downloaded from SharePoint, as well as a clean desk policy to safeguard personal information from the cleaning staff. Also, accessing company email on employee personal devices can increase the chance a breach could occur, since many of them may be lacking key security features, such as requiring an access code or a minimum length for a security code. Their solution is that when the employee downloads the Outlook app from their personal phone, the user must agree to terms and conditions, which include minimum access code requirements, as well as the ability to remote wipe the device in case of an emergency termination or if the end user loses the device or it gets stolen. This type of control allows for more security over personal devices, especially when the critical subject of email is involved. These are just some of the examples of proper policies that our mortgage lender clients are taking to be proactive instead of being put in a reactive situation. This next type of physical security breach really hits home for mortgage lenders. And as we stay on this slide, I really want to underscore the importance of pipeline theft. If Ginger, you go back one more slide, please. Thank you so much. So the trouble with pipeline theft is that many lenders do not even realize this type of activity can trigger data breach notification requirements. However, the topic of pipeline theft can be a major issue because even though the unauthorized activity of stealing loans occurs through a rogue loan officer, processor, manager, or believe it or not, entire branches that leave for another company, it will subject the mortgage lender to compliance consideration if those rogue actors take the borrower's personal information with them. Remember that the unauthorized use of a borrower's personal data can result in a data breach to the organization charged with protecting that information. That is the mortgage lender. Offending organizations can face fines, litigation, diminished reputation, and even loss of the right to operate the business. As I mentioned, we have seen entire branches defect and leave one lender to go to another and take entire pipelines with them. Just imagine your risk exposure in a situation like that. Unfortunately, pipeline theft is an issue that can cause lenders to lose much more than just sleep at night. Now, as we move on to the next slide with phishing, spear phishing, and whaling, these are various forms of phishing schemes with definitions and further explanations provided on this slide via a Department of Homeland Security report. It was important to note that within this same report, it was also stated that the initial point of compromise for significant security incidents is generally by way of phishing. These security incidents may adversely affect confidentiality, integrity, or availability of the information, and that included personally identifiable information. On the next slide, we have malware. This is an intrusive software that is designed to damage and destroy computer and computer systems. Malware is a contraction for malicious software. Examples of common malware include viruses, worms, spyware, adware, and ransomware as previously discussed. In addition to intrusive software, attacks can also occur through password breaches, as we have on the next slide. This happens when a user's password has been hacked or revealed, which can lead to compromised data, compromised systems, and people using accounts without your knowledge. When using passwords, it is important to understand that security outweighs convenience, and remember to keep in mind the following items I have listed. As we move to our next slide, this illustrates the importance of securing a borrower's sensitive personal information. This chart from IBM's Cost of a Data Breach report shows the types of records compromised and that 80% of data breaches included customer personally identifiable information. The gravity of this should really hit home for each and every mortgage professional. Now, let's compare E&O coverage versus cyber insurance. First off, many lenders may think that their E&O policy covers a wide variety of potential claims, but unfortunately, they are sadly mistaken. There are two types of E&O coverages for mortgage bankers. Mortgage E&O policies needed for GSE and warehouse bank requirements are limited to coverage for items such as failure to obtain or maintain insurance or pay real estate taxes. A professional services liability policy includes coverage for those negligent acts and errors and omissions which arise out of your professional services as a mortgage banker. With that being said, many lenders make the mistake to think that this type of coverage applies to all aspects of what you do, including repurchase request. However, this is generally not the case since these policies have many exclusions within them. In contrast, as we move to the next slide, a cyber insurance policy covers expenses and liability resulting from a release of customer or employee personally identifiable information. These can include, but are not limited to, the following costs I have listed, such as forensic and legal expense, crisis management cost, public relation expense, extortion, fraud response, business interruption, data asset restoration, third-party liability, those notification costs, along with social engineering. And although cyber insurance is not usually required coverage, it is highly recommended for mortgage bankers due to the current threat landscape. Now, on this next slide, we have an example of a cyber insurance policy declarations page, which shows a total policy limit of $1 million. It is extremely important to review your policy, understand the declaration page, and the definitions included within your policy. Below that, it shows a sublimit of the policy, which provides $100,000 for social engineering. A sublimit is a limitation in an insurance policy on the amount of coverage available for a specific type of loss. This will be part of your coverage limits and not in addition to them. For example, even though this total policy limit was for $1 million, because it has a sublimit for social engineering fraud, this limits that loss up to only $100,000 of the total limit, not in addition to. Once again, I can't emphasize how important it is to understand your cyber insurance policy, the declaration page, and the definitions that go along with it. Remember to ask questions during your cyber insurance application stage and any subsequent renewals. On the next slide, this shows the average cost per record for data compromised in a malicious attack. And this can be startling. IBM's 2020 cost of a data breach report documented the average cost per record for data compromised that contained customer personally identifiable information was the highest at $175 per record, $175 per record. As such, it is important to understand what your organization's potential data breach exposure is. If you take the $175 cost per record from the IBM report and multiply it by your organization's total records, this will help you quantify your potential exposure. When determining potential exposure, remember that this not only includes closed loans at risk, but also anyone who has submitted their personal information, such as for pre-qualifications, pre-approvals, loans in progress, denied, and withdrawn files. Needless to say, the potential risk and cost exposure can be extremely high and very scary. Now, if the unthinkable occurs, what happens after a breach on the next slide? First thing we do as a firm is to obtain a copy of your cyber insurance policy. We will review coverages, follow the claims process, and make timely claims. Make sure to keep your policy in a place where it can be readily accessible, even if all of your systems have been taken down. Strongly consider obtaining appropriate coverage prior to a breach, because obtaining cyber insurance thereafter may become difficult. You must also remember that it is critical to clamp down on unnecessary communications. And as discussed previously, you do not want to waive the attorney-client privilege by disclosing the confidential communication. Now, if the incident rises to the level of a data breach, this triggers notification requirements to those affected individuals, regulatory agencies, and potentially local law enforcement and the Attorney General. Thus, it is critical to know what your notification obligations are after a breach. Now that a breach has occurred and obligations have been triggered, have you determined if the data breach was a technical issue or theft? You will also need to evaluate insurance coverage and understand the process on how to make a claim. It will be important to make timely claims, since that will allow the forensic team to get involved and help determine the exposure of the breach. You should also review your policy and procedures, because it should provide for ways to reduce your exposure and provide the proper protocols on how to respond. When you look at your policy and procedures, don't just think of them as something to check off the list during your recertification or any state audit requirements or anything along those lines. Look at it as a way to build a backbone and a foundation for how your organization is going to respond and operate its business. Additionally, because all 50 states have varying data breach notification rules, there are different state requirements which include definitions, notification obligations, timing, penalties, and more. Your notification obligations may extend to multiple parties, such as consumers, state attorney generals, and consumer reporting agencies. Additionally, depending on your lender approval status, this can require notification to the agencies, or if a sponsored entity, then notification to your sponsor. There may be additional notice requirements for contractual obligations, such as those contained within many mortgage loan purchase agreements as well. As we move to the next slide, panel counsel refers to an attorney or law firm who is chosen by the insurance company to represent its policyholders when defending against liability claims. Depending on the carrier, panel counsel may be more oriented to general business and not specific to mortgage banking. When you are evaluating the panel, it is important to have mortgage banking counsel available, since not all breach counsel is aware of mortgage banking nuances. For example, while general breach counsel may understand when you need to report to state attorney generals, they may not need to understand separate reporting requirements to sponsored lenders, mortgage loan purchase agreements, LO agreements, and more. Prior to making a claim, we can be your initial point of contact to help with the process and act as your personal counsel. And once again, I want to underscore the importance while you're going through initial insurance applications and subsequent renewals. Make sure to ask your insurance agent, insurance broker, ask them pointed questions. Understand your policy, find out what the definition entail and how they're going to apply in case the unthinkable occurs. And as you probably know by now, if you do fail to take appropriate action after a breach, be prepared for significant consequences. These potential consequences include, but are not limited to, the following. And Ginger, if you could move to the next slide, please. So these potential consequences, remember, this is a short list, but they can include audit findings. How did these potential compliance considerations come up in an audit? Did your actions comply with your policy and procedures? Were these actions sufficient? We're seeing more and more questions, even on general routine state audits that come up, dealing with the issues of cybersecurity, breaches, etc. Potential regulator ramifications. Subject to attorney general enforcement, fines and penalties, and consumer actions. Private right of action versus tort. A private right of action allows consumers to bring private legal actions against businesses, which include mortgage lenders, bankers, brokers, and the like. With these private rights of action, most of the statutes do not include a private right of action where a consumer's information was included as part of the breach. Nevertheless, consumers will many times rely upon common law tort principles to go after you for any and all damages that may have been incurred as a result of the breach. So in closing, I want to thank you for attending today's important webinar. I want to thank Greg for getting everyone connected so we could have an opportunity to go over these important details. And I hope that there is high value with the information provided. And this will be an ongoing resource to help strengthen your data protection procedures. If any follow-up questions do arise, my contact information is listed here, or I can be reached by phone or email to discuss any scenarios or specific concerns that you may have. We look forward to being a continued resource for your mortgage banking legal needs. And if you have any other topics that you would like to reach out to Greg with, whether it be PPP forgiveness loan application, conditions that are being asked, whether it be renegotiating your MLPA agreements, whether at time of recertification or upon initial application, those are both topics we can discuss and go into great detail to help further show you ways to mitigate your risks in the lending world. Whether you're delegated, non-delegated, or the like, these can all apply equally and help strengthen your business. And Ginger, let me turn it back over to you with that.
Well, awesome. And we appreciate the information, Sean. Greg, if you want to hop back on, I want to remind everyone I am sending a copy of the recording and the slide deck. Sean covered a lot of information and making sure that you're keeping all of your information safe, what to do. It's so important to be able to have a plan. So first and foremost, have a plan. Second, if you don't have a plan, then obviously a great person to reach out to is Sean and the Thomas Mortgage Group. So Sean, we thank you for the information. I am going to be sending out a follow-up question as soon as you log off of this. So if you have questions for Sean that you would like for him to answer that he has not already covered, then you can submit that question. We'll get them over to Sean, and then we'll put together an FAQ and send that out. So with that, I'll go ahead and send you out. Have a great day. Thank you so much for attending. And we look forward to seeing you on an upcoming webinar. Thanks so much, Sean.
Thank you, Sean. And I'd like to remind everyone that if you have any topics that you would like to see us cover in a webinar, please send me an email or your account executive an email, and we'll get the information out to you, and we'll set up a webinar. But thank you, everybody, for joining. Sean, thank you so much. Very good content. Very informative. Thank you so much.
You're welcome, and thank you both for having me on. It was a great time.
Thank you.